Good morning. Happy Wednesday. I learned this morning, thank you, Mountain Mover, Motion Mover, MTN Mover, and somebody else. They both alerted me that there is, in fact, a loyalty oath that all public employees sign, not just public officials, in Arizona. Arizona is this weird state where they have the crossing guards who work part-time to get the children across the street for school sign a loyalty oath. So my general rule of thumb was is not really useful for Arizona. So to determine what a public official is, it's a question of fact, but it's a question of fact that's been settled for some specific things. For example, a elected official is a public official. They've been elected. So judges are elected. Even if they're appointed, a judge is going to be a public official. So, grain of salt. Senators, congressmen, mayors, school board members, public officials, they're all public officials. And then the other thing is people who have a lot of discretion are public officials. Discretion in things that affect the public. For example, police officers are public officials. Jail guards, prison guards are public officials. The staff members of the senators are generally speaking going to be public officials, especially the ones, there's going to be like breaking points where they're no longer considered public officials, but the ones who go out and speak and who convey the policy positions of the senators and congressmen and legislators and presidents and governors and things like that, those are going to be public officials. So, Marco Rubio is a public official. Now, in order for these things to, so just because you are a public official, let's say Marco Rubio, he's a public official. That doesn't mean that he can't, for example, have his own private, personal Facebook page or social media account. That doesn't mean he can't say things that are not in his official capacity as a public official. And so First Amendment issues won't attach to those kind of things. If he's not acting as a state actor, then the fact that he is otherwise a public official is immaterial. So it's a multi-step test. It's not just, are you a public official? And I still don't believe that the victim is a public official. She's a public employee. There's a difference. And even if you look at the loyalty oath, it says that this loyalty oath is given to officials and employees. Now, if all employees are officials, then why would they need to make that distinction? They wouldn't, but they do. Why? Because there is a distinction between an official and employee. So, it is a question of fact, but in my understanding of what makes someone a public official, first of all, step one, a essentially administrative position that reports to the dean. The dean is much more likely to be a public official than she is. She may be, but I don't think so. The odds of the court finding her to be a public official is somewhat slim. So, so the dean of the law school, much more likely to be a public official. The dean of the college in general, whoever that overarching administrative position is that makes policy decision about the entire college, much more likely to be a public official. The board of directors or whatever for the college, the Arizona, that whatever the board is called that deals with their state universities, they are public officials because they're elected. So you can kind of see the way it plays out. So determining whether someone is a public official is step one. Step two is determining if they were acting in their official capacity. And that's, again, where things break down, because she was not acting in her official capacity. She filed her particular petition, I think they call it a petition, maybe they call it a complaint for civil harassment restraining order against Lane Myers, she filed that in her personal capacity as a private citizen. There's nothing that says that they can't act as non-public officials. And one of the things that Lane Myers was suggesting was that you could call a public official all day long and, all they could really do is let it go to voicemail. Well, kind of yes and no. So if you call the public official on their publicly, like on the line that goes to their office for their public office, absolutely. You can call the police station and leave complaints about officers. You can call your governor and leave complaints about the way he does stuff. You can call your congressman and leave complaints about the way she does stuff. Whatever. You could do that. But the next question is, can you contact them like on any channel? Can you contact them on their private phone number? Let's say you get their private information and you call them on their private cell phone. I'm not saying that he did or didn't. I'm just saying this is a hypothetical arguendo situation because Lane Myers made a blanket statement. Now, in that particular case, can you just call and harass someone that is a public official on their private, non-governmental phone number? I don't think you can. I would suggest to you that you probably could get popped for harassment. Even though they're a public official, you're calling them in their private capacity. That if a public official, again, going back to your neighbor is a police officer or a sheriff's deputy or whatever, someone who is considered to be a public official, and you invite him over to your house for a swimming pool party and he gets drunk and takes a shit in your pool. Well, he's not acting in his official capacity. He came over as a private citizen. He's acting in his capacity as a private citizen. He got drunk in his capacity as a private citizen. He's not wearing his uniform. He's not on the clock. He's just your neighbor. He's just your neighbor. And his employment in that instance is not material to this. So regardless of anything else, even though literally every employee of the state or one of its political subdivisions, down to the lowest of the low, a grandma who spends 2 hours a day helping kids learn to read after school and gets paid, for one of those 2 hours, she would have to sign this loyalty oath. But you can see it's in ARS like 38231. I could be wrong about that. It's somewhere in there. But it basically says, I support the Constitution. What does that mean? Who knows? Who cares? It doesn't mean that they have to interpret the Constitution like you interpret the Constitution. And that's another thing. It's always sovereign citizens who are bringing up these oaths of office and demand to see the oaths of office. Apparently, you can file a request, public record request to see anybody's oath of office, or loyalty oath, I think they call it in Arizona. You could file an open records request in Arizona to see one of these things, but who cares? Saying I support the Constitution, what does that mean? It doesn't really mean anything. And again, they're not bound to your particular interpretation of what the Constitution is. So what does this mean for Lane? Like, let's say that he gets the victim on the stand. He had a big hard-on to cross-examine the witness. Here's some issues. First of all, the scope of his cross-examination is going to be limited to what was raised on direct. That's number one. Number two, she's not on trial. Number three, her oath of office, since she's acting in a private citizen, is irrelevant to this entire thing. Number four, even if she does have an oath of office, which I believe she would, or a loyalty oath. Again, I'm confusing these terms, so Arizona's a weirdo state in this aspect. But even if she does have one, Lane's burden still hasn't shifted. Lane's only defense is that he's admitting he's doing the thing. His only defense is it's First Amendment protected. That's the only defense that he's raised. He's admitted to doing everything. So, like when the public defender said, if under the law, if it's this way, I'd have to find him guilty. That was an argument, first of all, to try to suggest to the court that the current understanding is wrong and it's overbroad and vague. But yeah, it's true. Regardless of that, it's still true. The law, as I understand it, Lane Myers is guilty unless it's protected speech. And so the burden is on Lane Myers at this point, because he's essentially admitted to everything. He's filmed himself doing these things. The burden is on him to show this protected speech. Now, that burden doesn't change just because she has a loyalty oath. He's trying to put her on trial and say, well, you violated my First Amendment rights. No, she went to court. The court made a determination that what she was doing, or that what Lane was doing was not protected by the First Amendment. He made that argument in the civil harassment restraining order hearing. He suggested that it was protected by the First Amendment. The court listened to that and rejected it. So there's a court that made a determination that his speech wasn't protected by the First Amendment already. So everybody who thinks that a court is going to magically find it was protected by the First Amendment, you got to look at this and understand that it's already been raised now in multiple courts, and the courts have each time rejected it. Does that mean that a court of appeals won't say maybe there is something here? No, I mean, a court of appeals could still find that there is a First Amendment protected action, that what Lane is doing is First Amendment protected activity, and or that the statute is overbroad. But no court yet has found that, and he's raised it now in at least two courts, if not more. So two separate judges both said, not First Amendment protected. Sorry, Charlie, you're wrong, and you lose on this issue. So the burden of proof still hasn't changed. Lane has to show that what he's doing is First Amendment protected activity. And then if he shows it's First Amendment protected activity, the loyalty oath is meaningless. It's meaningless. And if he doesn't show it's First Amendment protected activity, the loyalty oath is still meaningless, because there's no violation of the First Amendment. But what he's doing is actually trying to add more steps to it, because for the loyalty oath to have any meaning at all, he'd have to show that, number one, what he's doing is First Amendment protected activity. Number two, that she didn't have any right as a private citizen to bring a civil suit against him for the restraining order, and that somehow violated his rights, that she knew or should have known that it violated his rights, which is going to be impossible for him to prove, because two courts so far have suggested that it wasn't First Amendment protected activity. So, anyway, all I'm saying is, like, it's a loser. The loyalty oath is a loser issue for him. It doesn't change anything. Everything that he has to do is to prove that his speech was protected by the First Amendment, and or that the harassment statute, the criminal harassment statute, is unconstitutional. He's got to do one of those two things. His speech is protected, or the criminal harassment statute is overbroad. If he can't do those, he's sunk. Like, that is it. That is the sum total for everything everybody wants to argue about Rayleigh's or camp manager trespassing him, not Rayleigh's, O'Reilly's, or the camp manager trespassing him, or when he made a phone call, or this or that or the next thing. Oh, he never contacted her, whatever, blah, 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 blah. She never told him he was harassing her, whatever. None of that shit makes any lick of difference. The only thing that makes a difference, the only thing, he's got one of two ways to go. Number one, the statute is overbroad and violates the First Amendment. Or number two, that his speech was protected speech under the First Amendment. Those are the only two outs he has. So everything else is irrelevant. Everybody who said, oh, you need to know the backstory from the very beginning, I guess I didn't, because we're down to two things being relevant. Did he have protected First Amendment speech? Was his speech First Amendment protected activity? And number two, was the statute overbroad? One of those two things. That's two routes to victory. That's it. That's all he's got. He's got a chance, but he doesn't have a great chance of winning on either one of them. He could, but it's not a great chance. I don't know. I'm not going to put numbers to what his chances are. It wouldn't shock me if a court found that actually the criminal harassment statute is unconstitutional, but But if I had to bet on it, if I had to put money on it, I'd bet the court would find that the statute is constitutional. And this isn't going to go to the Supreme Court. It's not going to go to the Arizona Supreme Court. It's not going to go to the U.S. Supreme Court. It's going to die an ignominious death, probably in the Court of Appeals for Arizona. He may take it to a district court, a federal district court on a habeas, but it's going to die an ignominious death there as well. And he may even appeal it from a district court to the Ninth Circuit Court of Appeals. But it's going to, I mean, he's not going to get to the Supreme Court. He's just not. I don't know if he'll have enough time to get it to a court of appeals. I don't know if his sentence will give him enough time to get him to a federal court of appeals. Anyway, that's all I got for you today. Thanks for watching. Have a great day.